In the Commission of Enquiry issued under the Constitution of the Republic of the Gambia to inquire into the financial dealings, assets, etc. of ex-President Yaya A.J.J. Jammeh, his family members and close associates, and in the matter of an application by Amadou Samba for the discharge of 2 interim orders of the Commission of Enquiry, both dated 13th of October 2017. Today, dated 30th October 2017. Present, Amadou Samba, the applicant. Mary A. Samba, counsel for the applicant. Ami Bensouda, counsel assisting the Commission. Ruling. Consequent on the deliberations by the said Commission of Inquiry, assisted by counsel to the Commission, the Commissioners on 13th October 2017 made suo motu 2 interim orders which are annexed to this ruling. The first order is the one commencing with the name Mohammed Bazi, hereinafter referred to as Order A. And the second order is the one commencing with the name Lieutenant General Suleiman Baji, hereinafter referred to as Order B. Order B names 4 family members of ex-President Jammeh and also 13 individuals, including the applicant, Amadou Samba, as close associates of the said ex-president. Order A names Mohammed Bazi, Fadi Mazegi, and the applicant, Amadou Samba, as board directors and or substantial shareholders in some of the 20 companies listed in the order. By Order A, the applicant Amadou Samba, Mohammed Bazi, and Fadi Mazegi are restrained, A, whether by themselves or their officers, servants, agents, or any of them, or otherwise, howsoever, from selling, assigning, mortgaging, charging, or otherwise disposing of any of their movable or immovable assets, whether directly or indirectly owned, including shares, stocks, debentures, or other interest in any of their companies or businesses in the Gambia or outside the Gambia, pending the further order of this Commission or the outcome of this inquiry. B, whether by themselves or their officers, agents, or any of them, or otherwise howsoever, removing from the jurisdiction any of their aforesaid assets or doing anything that may reduce the value of the said assets, pending further orders of this inquiry. It is important to bear in mind that the order granted to the above named persons including the applicant Amadou Samba, liberty to apply, meaning that they are free to apply to the Commission of Enquiry for the variation or complete discharge of the said order. Upon such an application, backed by legal and or factual arguments, the commissioners are empowered to vary if variation is asked for, or to set aside if discharge is asked for, their entire orders. By Order B, all the said 13 persons, including the, the listed applicant, were declared to be close associates of ex-President Jammeh, and they, together with his family members, are restrained in the same terms as in Order A. Order B then made the following further orders, and as follows: the assets of known family members and close associates that are out of the jurisdiction are hereby frozen pending further orders of this Commission. 4, members of the public are invited to provide any information they may have regarding assets owned by such persons in or out of the country, and such information shall be treated as confidential. 5, the above named persons are at liberty to apply. 6, the order shall be published in national newspapers of wider circulation. I consider it noteworthy that of the 17 persons affected by the said orders of the Commission, only Amadou Samba, the applicant, has put in an application. This was notified to the Commission by letter dated 28th October 2017 by his solicitor, Mrs. Mary Abdullahi Samba. Paragraph 2 of that letter reads, quote, unquote, I intend to move the Commission on certain applications before the Commission on the interim orders made against my client dated 13th day of October 2017 and served on my client, and an order dated 13th day of October 2017 published in the Standard newspaper, Point, and other newspapers circulating in the Gambia. There was and is no objection to the form the application herein took, since the Commissioners announced at the very start of its public sittings that the notice of motion and affidavit in support would rarely be admitted, because unlike oral application, it has a proclivity towards protracted legal tussles which would benefit no one. Notice was earlier given to the applicant to move his application on 25th October 2017, and on the date he said counsel, Mary Samba, in the presence of her client, announced her representation and argued his case as summarized below. According to Mrs. Samba, her client, Amadou Samba, had been summoned to appear before the Commission as a witness. He spent time with the Commissioner's investigators, but before he actually appeared before the Commissioners in open session, he was made aware of the two said orders of the Commission, one of which was served on him personally and the other through newspaper publications. Counsel for the applicant, Amadou Samba, clearly stated her single prayer regarding the Commission's orders A and B, to wit, that the orders be discharged on several grounds. The grounds are: 1, that under Section 205 of the Constitution, the applicant is entitled, quote, to the same immunities and privileges as if he or she were a witness in proceedings before the High Court, unquote. Counsel did not elaborate on this point. Nevertheless, it seems to be implied that the said immunities and privileges ought to have been granted to the applicant, but were not. 2, that no formal notification was given to the applicant prior to the issue of the orders, thus depriving him of an opportunity to react by cross-examination of witnesses who testified that he was a close associate of the ex-president. 3, that there should have been a public hearing of the matters giving rise to the said orders. 4, that a rule of natural justice, to wit, audi alteram partem, was not complied with by this Commission in the same manner that the Commission fundamentally breached the Constitution of the Republic. Applicant's counsel referred to Section 24 of the Constitution, particularly the provisions as to fair hearing. 5, that the Commission went beyond the terms of reference. See Legal Notice number 15/2017, issued and gazetted by the President of the Republic, in particular the paragraphs thereof specifying the authority of this Commission of Enquiry. Therefore, applicant's counsel submitted that the Commission acted ultra vires, that is, beyond its powers, by making the said orders, which are, according to her, quote, unquote, enforcing rather than recommendatory. 6, that Section 202, subsection 2, paragraph D, allows this commission to make interim orders only in relation to witnesses' attendance or the production of documents. Asked by the chairman of the commission whether she had anything to say on the matter, counsel assisting the commission, Mrs. Ami Bensouda, submitted that the interpretation of the constitutional provisions on interim orders was misconceived. Interim orders are permitted even in a court of law, as can be seen in orders 11, 12, and 13 of the rules of the High Court. However, it must be noted that the Commission has original jurisdiction to issue interim orders, but may look at court procedure only by way of analogy. The power of the Commission to make interim orders is unlimited. Counsel assisting the Commission also submitted as follows. 1, that Amadou Samba, the applicant, though a witness, has been found and named by the Commission to be a close associate of the ex-president and subject to interim orders. 2, the Commission has jurisdiction to make ex parte orders by analogy and deal with the matter without, in the absence of the applicant otherwise. Its orders might be nugatory, since a witness knows that an injunction could be made concerning his assets, would naturally take steps to dispose of them. 3, the constitutional provisions should be interpreted purposefully to give practical effect to them. 4, the witness can hardly take the position that he was not aware of the proceedings of the Commission, which have been extensively published in newspapers, television, social media, and radio. Five, the interim orders themselves put the applicant on notice, and he had every right to challenge any order, since he had liberty to apply as stated in the orders themselves. 6, there was nothing stopping the applicant from having access to the documents and transcripts of testimonies, which are all in the public domain. At the beginning of her argument on the oral motion, counsel for the applicant Amadou Samba informed the Commission that the sole relief she was seeking from the Commission was the discharge of the said interim orders A and B. At the end of the address, she was asked by the chairman what reliefs she was asking for, and the unequivocal answer was, quote, the discharge of the interim orders, unquote. Clearly then, the application of Amadou Samba was not for the variation of the said orders, but for their discharge. Council did not put forward any suggestion as to the issues that call for the termination of the application herein. We shall proceed on the following issues for determination. 1. Whether or not this Commission acted ultra vires contrary to the Republican Constitution and or the law of the land. 2. Whether for any legal or factual reason the interim orders A and B ought to be discharged. These are the two issues for determination. The two issues for determination are herein considered together and not one by one. However, before delving into the issues, it is believed that a short historical backdrop to the legal foundation of commissions of inquiry should assist our deliberations and facilitate the understanding of all persons concerned. On 22nd July 1994, the AFPRC, that is to say, Armed Forces Provisional Revolutionary Council, staged a coup d'etat, established a military dictatorship, and sanctified the slogan, accountability, transparency, and probity, quote unquote. The APRC quickly passed several decrees, later converted to parliamentary acts, for the issuance of commissions of inquiry and for the freezing and forfeiture of assets linked to mainly public officers strongly suspected of unlawfully acquiring public funds and or landed properties. The said decrees / acts are still existent in Cap 2901, Cap 2902, Cap 2903, Cap 2904, and Cap 2905. The first of them having been passed in 1994, that is to say, the Public Assets and Properties Recovery Act. It is important to note that it was not the APRC that introduced the Commission of Enquiry to the Gambia. The first Commission of Enquiry, still in the statute books, is the Commission of Enquiry Act, Cap 3001, which was passed during the colonial era in the year 1903. That is to say, 114 years ago. That statute is extant and binds this, our Commission of Enquiry, to the extent that it is consistent with the 1997 Constitution of the Republic of the Gambia. In 1997, the Constitution was passed. All the acts mentioned above predate it, but it is the Lord of all laws in the Gambia, although in some other countries the supremacy of Parliament is the norm. The jurisprudential dichotomy inherent in the Gambian Constitution, where it is the supreme law of the land and at once the foundation of all laws, where it is at the top and at the same time at the bottom of all laws, is a mystery only to the uninitiated. Suffice it to say that Section 4 of the Constitution reads, quote, "The Constitution is the supreme law of the Gambia, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void," unquote. In dealing with the said interim orders under attack by the applicant's counsel, I should from the outset remind myself of the practice backed by judicial pronouncement of this of saying very little on the facts in this interlocutory matter in order not to prejudice the proceedings of the Commission, especially when Amadou Samba, the applicant, is yet to complete his testimony. Be that as it may, it is considered useful to raise and reaffirm certain facts emanating from the face of the interim orders themselves, taken as a whole, to wit, one, that Amadou Samba, like others named therein, are considered close associates of ex-President Yahya Jammeh. Two, that over $200 million and over $10 million US have been lost to the government of the Gambia and the people of the Gambia, and investigations are still ongoing. Three, that the applicant had or has interest in several of the listed companies. Four, that it is necessary and or prudent to avert the risk of these persons, the applicant included, disposing of their assets or reducing their value pending the completion of this inquiry, as Clause 17 of the Interim Order A puts it. It is evident that the Gambia is a highly indebted poor country. Therefore, the stated sums of lost money are colossal by Gambian standards. Every effort to restrain the disposal of property by persons who might turn out to be adjudged potential culprits is in the public interest. Relying on Section 200, subsection 3 of the Constitution, counsel for the applicant challenge this commission for not holding public proceedings in issuing the said interim orders. But Section 2, subsection 3 of the Commissions of Enquiry Act 1903, Cap 3001, provides, quote, except as may be ordered by the presiding commissioner in the public interest. I emphasize, in the public interest, public safety or public order, the proceedings of a commission of inquiry shall be held in public. I repeat, except as may be ordered by the presiding commissioner, that is the chairman, in the public interest, public safety, or public order, the proceedings of a commission of inquiry shall be held in public. Otherwise, it certainly can lawfully be held in camera. This section is in no way inconsistent with the Constitution, but complements it. As submitted by counsel assisting the Commission, this Commission acts by analogy with certain rules of the High Court. This is rightly done to preserve consistency and harmony as far as possible between judicial and quasi-judicial state institutions for the sake of good governance and the benefit of the people. Thus, the applicant's objection that this commission did not conduct public proceedings in issuing the said interim orders cannot stand and is hereby rejected. The applicant's counsel also challenged the right of the Commission to proceed ex parte, that is to say, without the applicant's attendance and without any notice to him to attend. She further submitted that by not giving notice to the applicant to attend, the proceedings for the said interim orders and by holding the proceedings in his absence, the Commission violated the constitutional provisions for fair hearing as well as a rule of natural justice, that is to say, audi alteram partem, which means here the other party. It has already been shown that this Commission of Inquiry is not a court of law and acts by analogy with some rules of court. The rules of the High Court relating to motions can be found in Order 25 thereof. Rule 7 of Order 25 reads, motions, quote, motions may be made either ex parte or after notice to the parties to be affected. Motions may be made either ex parte or after notice to the parties to be affected. And Rule 9 reads, Rule 9 of Order 25 of the Rules of the High Court reads, quote, a party moving in court ex parte may support his or her motion by argument addressed to the court on the facts put in evidence. And no party to the suit or proceeding, although present, other than the party moving, shall be entitled to be then heard. This clearly shows that in ex parte proceedings, even if the other party is coincidentally present in court whilst the proceedings are underway, the other party is not entitled to be heard at that point in time. Fidelis Noah Jallo, in his highly respected book, Civil Procedure in Nigeria, second edition, states at page 584, quote, the grant of an interim injunction on an application made ex parte does not offend against the right of fair hearing under Section 36(1) of the Nigerian Constitution, unquote. Like Noah Jallo, I cite as persuasive authority the case decided by the Nigerian Supreme Court, 7-Up Bottling Company Limited versus Abiola and Sons Limited, 1995, 3 Supreme Court of Nigeria Journal at page 47. The issue of legal representation of the applicant should not arise at all. Adequate notice was given by this commission of the commencement of its sittings. From the onset, the chairman of the commission explained in open session the oral nature of its proceedings and also made known the obvious right of persons affected or interested to be represented by lawyers before the Commission of Enquiry. In fact, Section 14 of the Commissions of Enquiry Act 1903 provides, quote, a person whose conduct is the subject of inquiry under this Act, or who is in any way implicated or concerned in the matter under inquiry, is entitled to be represented by counsel at the whole of the inquiry, and any other person who may consider it desirable that he or she should be represented may, by leave of the Commission, be represented in such manner. Unquote. The commissioners had no duty to inform anyone of their right to hire counsel to appear before the Commission. The many public sittings in which his name was mentioned the many public sittings in which his name was mentioned, and any intelligent assessment of the huge news generated by the proceedings of the Commission, coupled with his own relationship with the ex-president, so publicly manifested prior to his democratic removal through the ballot box, ought to have awakened the applicant, Amadou Samba, to the fact that he might be implicated, concerned, or make him find it desirable to use the words of this section just quoted, to hire a barrister or solicitor to represent him before the Commission from the inception. Thus, his counsel's argument relating to lack of legal representation during the Commission sittings do not hold water, and they are hereby rejected. It was the applicant's argument that the powers bestowed on this Commission of Enquiry by the Constitution, the Commission of Enquiries Act 1903, and His Excellency the President's terms of reference were exceeded, and therefore the Commission acted ultra vires, that is, beyond its lawful powers. We find it necessary to deal with the issue of ultra vires only in relation to the constitutional provisions which we firmly believe give us all the powers we have exercised and are in sync with the powers conferred on us by the said Act and the presidential terms of reference. Counsel for the applicant made reference to Section 202, subsection D of the Constitution, subsection 2D of the Constitution, and submitted that the power conferred thereby on this Commission to make interim orders is exercisable only in relation to the attendance of witnesses and compelling the production of documents. We find this submission insupportable because the way to deal with recalcitrant or contemptuous witnesses is catered for in Section 13 and Section 18 of the Commissions of Enquiry Act 1903. Section 202, 2D of the Constitution grants the Commission of Enquiry, quote, all the powers, rights, and privileges of a judge of the High Court at a trial in respect of making interim orders. The powers granted by D are wide and independent and not circumscribed by any statutory provision outside the Constitution itself. Thus, this challenge of the applicant fails. We note, as suggested by the applicant's counsel, Section 205 of the Constitution, as well as Section 2 of the Commission of Enquiries Act, which makes witnesses entitled to all immunities and privileges, including non-compulsion to answer incriminating questions whilst giving evidence before the High Commission. However, we fail to see the relevance of witnesses' privileges and immunities in this application, which does not involve the giving of evidence before the Commission. Appellant's counsel sought guidance as to the interpretation of paragraph 3 of the interim order B. We decline to offer guidance as a request for guidance. On an order can only be, cannot, I'll read it again. We decline to offer guidance as a request for guidance on an order cannot be joined with an application to discharge the order. For all the reasons given, we are unable to resolve the issues for determination of this application in favor of the applicant. Therefore, the application fails in its entirety and is dismissed.
As the Commission pleases.
Thank you.
Honorable Chairperson.
I agree.
I agree.
Very well. I will hear you.
Honorable Chairperson, I would like to be availed with a copy of the ruling of the Commission. I would also wish to apply for the record of proceedings to date from the Commission, if that is possible. And certain allegations made by witnesses before this Commission has been brought to the attention of my client, and he would like to be given an opportunity to respond to them.
Certainly.
As the Chairperson pleases.
I'll take them one by one. It has been known, made known right from the start that these are public proceedings and all documents and testimonies are available to the public. But the application cannot be made here. You make the application to the Secretariat and they'll certainly deal with it. As for the ruling, as soon as it is ready, you can apply, and it will be automatically given to you. We believe that everything will be typed and ready within the next couple of days. Now, as for the witnesses that have made allegations, when we start proceedings, because you will know very soon that we are going into recess for about 7 days. But when we start proceedings, and after Mr. Sama, who is still a witness, shall have completed his evidence, you can make any application you want to make concerning the cross-examination of witnesses. I believe that answers your 3 questions.
Thank you, Honorable Chairperson. I just heard you mention a recess by this commission. I just want to give an indication that my client would like to travel out of the jurisdiction, and if there's a recess, he would like to take the opportunity to travel, just so that I inform the commission that this is his intention.
As I said, you will have to communicate with the secretary. These things cannot be dealt with here. But I can assure you that it's not difficult at all for a witness to have permission to go abroad.
Most grateful.
All right, we shall rise, but as I said, there will be a recess and we shall resume sittings on Tuesday, the 7th of November at 10 o'clock.
Thank you.
Sorry.
Thank you, Mr. Chairman.
Sorry.
Thank you, Mr. Chairman. I would firstly like to thank the commissioners for a very clear exposition of the law and the rules that guide this commission going forward. I'm sure it will be very helpful to other. Yes. Yes. I would like to thank the commission for a very clear exposition of the law. I'm sure it will guide all other witnesses and persons affected who are the subject matter of the investigations by this commission. I'd also like to inform the commissioners and particularly the Secretariat that Mr. Samba, this witness, would be required to continue with his hearing on the 13th of November. 13 of November. I assume we are coming back on this. What was it? 7th. A week after we come back. 13th of November. 13th, 13.